Hi, this is Stuart Talley. I'm one of the partners responsible for the Stryker Rejuvenate litigation. The purpose of this video is to provide an update on the status of the litigation. We plan to provide updates at least on a monthly basis so that everyone out there knows what's going on with the litigation. As many of you may know, there are thousands of Stryker Rejuvenate cases that are pending around the country and many thousands more that we expect to be filed shortly. To deal with cases like this where you have thousands of people all asserting claims with respect to the same type of medical device, what the court system does to increase efficiency is they consolidate those cases. So the majority of these cases are now consolidated in Minneapolis, Minnesota. And the first thing that the judge in this case has done is appoint a group of plaintiffs' firms to be on what's called the Plaintiffs' Steering Committee. There are several hundred law firms that have cases on file, but what the judge wants to do is appoint a small group of firms to actually handle the day-to-day litigation on the plaintiff side. At Kershaw Cutter, we are on that Plaintiff Steering Committee. We had our first hearing before the judge in Minneapolis on November 21st. This was the first hearing after this committee had been put together. We're very early in the litigation. There was a lot of preliminary issues discussed at this hearing. The first thing, at least some of the big things that have been discussed, are protective orders. There's a dispute between the plaintiffs and the defendants about the scope of protective orders. And when I say protective orders, what I'm talking about is confidentiality orders. Many times in these cases, the defendants want some mechanism to make sure that all documents that they produce in the case remain confidential and aren't released to competitors, the public. So there's a dispute as to how broad that protective order should be, and there was discussion on that issue. The other issue that is in the works that is being addressed at this point is something called plaintiff fact sheets. In these cases, where you have thousands of people all asserting the same claims, there has to be a mechanism to allow the defendants to get information about every single case that's out there. And instead of doing full-blown discovery like you would do in a normal lawsuit where you have one plaintiff, one defendant, they try to come up with an expedited process of getting information to the defendant. And that process results in something called a plaintiff fact sheet, which is essentially a long questionnaire. There's a dispute right now, and there's discussion between the plaintiffs and the defendants on what that plaintiff fact sheet should look like. Plaintiffs like to keep the fact sheets simple, short, and really down to the bare bones so that the defendants are getting the information they really need about the cases that are out there. On the other hand, defendants typically like to make them very long, complex, complicated, where much information from each person who has a case is disclosed in this questionnaire. So negotiations are ongoing right now as to what that plaintiff fact sheet will look like, and if it can't be resolved, then the judge will decide. If there's an agreement reached between the plaintiffs and defendants, there will be a fact sheet that will go out to everyone who has a case. The other thing that was discussed at this first hearing was service of complaints. When you file a lawsuit, one of the things you have to do is you have to serve the defendant with the lawsuit. When you have thousands of similar cases, it can be very expensive if you have to actually send a process server out to Stryker's headquarters to serve the complaint. So what we discussed with the judge was coming up with an expedited process for serving complaints, where you just basically email the complaint to the attorney for Stryker. Stryker has agreed to do that, but with respect to only their one of the defendants. There's multiple companies that were involved in the Stryker Rejuvenate, and they've only agreed to service on one of the defendants. And so there's a dispute as to whether service can be made in this expedited fashion with respect to all of the other defendants. If we can't resolve that dispute, the judge will eventually decide. The last thing that came up when when the plaintiff steering committee met was this process of using or cooperating with other jurisdictions. Not all of the cases are in Minneapolis. There are many cases that are filed in state courts in New Jersey, Florida, and Oregon. Those state court proceedings are separate and distinct from the federal court proceedings, which are in Minneapolis. So at this hearing, there was a lot of discussion about cooperating with these other jurisdictions so that the lawyers in New Jersey aren't doing something completely different from the lawyers in Minneapolis on the plaintiff side. So there has been discussion with the lawyers involved in these other jurisdictions, and there's going to be an effort to consolidate or at least cooperate with respect to sort of the procedural issues that take place. For example, if we take the deposition of a Stryker employee in the Minnesota case, what Stryker doesn't want is that employee to be deposed again in New Jersey and deposed again in Oregon and once again in Florida. They want all of these depositions to take place in one shot. So there was discussion about cooperation and coordination with these other jurisdictions, which on the plaintiff side is something that we want to do. We want coordination and cooperation because it benefits everybody at the end of the day. So that's basically what's been discussed at the hearing. There's another hearing next month on December 12th where additional issues will be resolved, especially these issues with the fact sheets and protective orders. If they can't be resolved, the judge may issue some rulings on that date. We're still early in the litigation. We still haven't started obtaining discovery from the defendant yet. And the discovery that we're talking about is typically documents, and there are millions of pages of documents that we need to get from the defendant. And so that is sort of going to be the next battle that we fight in this case. Defendants don't like to give us documents, and on the plaintiff side, we like to get all the documents that we possibly can. There's also disputes as to how those documents are going to be searched, what the defendants are going to do to get us those documents, and how they're going to be produced. We want them produced in an electronic format so we can search them and look at them. We also want the defendants to search for them in a specific way. So that's where we are. If you have a Stryker Rejuvenate hip, feel free to give us a call. You can reach us at the phone number on the screen. You could also reach us through our website, and we'll be happy to give you more details on the status of the litigation or help you with a case that you may have against Stryker.
Can you tell me